I'm Jim Zeifer with Preferred Planning Services, and I'd like to talk with you about a situation that I encountered in the past week with a family that I visited with. I met with a fellow who was with his dad, and they were worried because his father was 85 years of age, and Dad had asked that the son's name be put on his bank accounts, and so they went to the bank and they did that. When the son did that, he discovered that as he was trying to pay some attention to what his dad was doing and helping with his finances, he realized that his dad had been giving money to a friend. It was an old high school sweetheart that he had reconnected with, and in an effort to help her out, he had been giving her money. And the son was concerned if there were any problems with that. So a couple of things that we talked about was the fact that those are considered gifts if Dad's health fails and he has to go to a nursing home, that the state of Ohio would like to penalize his dad for the fact that he made those gifts. And if he ended up in a nursing home, he may find it difficult to provide for himself because after his funds have been exhausted, the state would then implement this penalty, which is a period of time determined entirely by the value of what he had given away or the amount of money that he had given away. So one of the things that we talked about was the fact that gifting, while it's an easy thing to do, can have unintended consequences if Dad develops health problems that prevent him from staying at home. The second thing that they didn't think about was the idea that the son was on the bank accounts could be very dangerous in that if the son has a legal problem or a health problem of his own or dies prematurely, that Dad's funds could be entirely tangled with the son's funds, and they never even had considered that. So we talked about the idea that maybe rather than having the son's name on the accounts, it might be a better idea to just have the son use a power of attorney, that he should maybe consult with an elder law attorney, someone that's has expertise in that area, and rather than having his name on the account, that he would be better served to use the power of attorney to do the banking for Dad. It would give him the ability to do it as if his name was on the account, but without having any of his liability imposed on the funds.